My name is Michael McDonald. I'm a Mi'kmaq lawyer from Sipekne'katik First Nation. I became involved in this case back in 2018, in December of 2018. And so it's been a long journey to get to that point where we finally made it into the start of the trial. The Crown was trying to get us to do agreed statement of facts, but we refused. We refused agreed statement of facts because basically, that's what they try to do in all these cases. They try to get lawyers to sign agreed statement of facts, and a lot of times they do. And the sad reality is that you're just admitting to these offenses, what you're being charged with, and I don't believe that my clients are guilty of anything because they're fishing for a moderate livelihood, which they have a right to do. In September, we had the first part of the trial, and so the Crown called their witnesses, right, because they had to prove the actus reus, so the act of the offense, right? So he called in 5 DFO officers, and each officer I got to cross-examine, and I asked each one individual officer if they actually went out and checked the traps because they were charging my clients under FSC. The Crown argued that my clients were fishing for food, social, ceremonial, but they weren't. They were fishing for a moderate livelihood. And I asked each officer if they actually went out on the water and checked the traps that my clients were fishing from, and each DFO officer said, no, they did not. So the Crown couldn't prove beyond a reasonable doubt that my clients were fishing FSC, nor could the Crown prove that FSC is the only type of fisheries that Mi'kmaq people are authorized to fish under. And so because we also have livelihood fishing, I asked each DFO officer, Department of Fisheries officer, if there was anything within the Fisheries Act or its regulations that deal specifically with livelihood fishing, and each officer said there wasn't. And then one of the witnesses the Crown called also was one of the heads of Department of Fisheries here in Nova Scotia. She came in and testified, and then I asked her the same question. She said there wasn't anything within the confines of the Fisheries Act that deals specifically with livelihood fishing. And because of that, the judge basically stated that courts couldn't bring judicial notice to this case, meaning that they couldn't bring in evidence because there was no laws to break. And so therefore, my clients were dismissed of all the charges because they were all Fishery Act related charges. And again, the judge said that the Crown didn't prove that FSC is the only fisheries that we're authorized to fish under. We're authorized to fish under Marshall as well. We have a right to fish for a moderate livelihood that was affirmed by the Supreme Court of Canada. However, it's been over 20 years, and Parliament has never once made any changes to the Fisheries Act to include a livelihood fisheries. And so that falls on Parliament. And because there's nothing in the Act that regulates a livelihood fishing, every time Department of Fishery officers come and they harass Mi'kmaq fishers, or they arrest them and charge them under these other, sections of the Fisheries Act, they're acting outside the law. So basically their actions are illegal. They're infringing a Mi'kmaq right. They're infringing a right to a moderate livelihood. And it's continuous. They're continuously doing this to our people. They're racial profiling. They're treating, Mi'kmaq people like they're criminals. They make you feel like you're being, the way they're acting, they make you feel like you're a criminal, like you're doing something wrong. But in actual fact, you're not. You're just practicing your inherent right, a treaty right that was affirmed, like I said earlier, by the Supreme Court of Canada. And so, again, they're just acting outside the law, and they're not doing their due diligence. Like in my case, with my clients, and they never went out and checked the traps to make sure that my clients were actually fishing under FSC. They just make an assumption, they must be fishing for food, social, ceremonial. They must be doing some illegal activities. We better charge them. Take all their gear. In my case, they took my client's father's truck. It was a brand new truck. He just had it for like a month, and he let his son use it. And DFO took the truck and wouldn't give it back, even though in the initial stages of this, the Crown at that time said he had no issues with, DFO releasing the truck. They refused. They kept the truck. And then my client's father continuously has been paying, the lease on that truck every single month because he was in the leasing agreement with the dealership, right? So you got 4 years of paying on a vehicle that DFO had impounded in their yard, even though the Crown in the beginning had said he had no issues with releasing the truck. I did file a notice of constitutional argument, and in my argument, my legal brief, I laid out everything. I laid out the Marshall decision. I laid out, what case law has stated with regards to, when it comes to fisheries. I laid out what, I even spoke about this FSC because they have this limitation on how many lobsters a Mi'kmaq person can catch, but that limitation is only in LFA 34. In every other area in Nova Scotia, there's no limit on how many you catch. If you wanted to catch 1,000 lobsters in LFA 33 or 35, then there's no issue. But in LFA 34, they have this limitation. And I addressed that as well because you cannot infringe your right unless it's for, a justified infringement, such as, for conservation purposes. And you can't say that there's a conservation issue regarding lobster, especially considering how many commercial licenses there are in LFA 34. So it's an unjustified infringement that still, enforcing today when it comes to food, social, ceremonial fisheries, just for LFA 34. And the main reason is because of Southwest Nova. Majority of the members of Southwest Nova all have fishing licenses in LFA 34. So they kind of they kind of direct the government and how the fisheries should be run because they're huge taxpayers, right?
These are non-natives?
These are non-natives, yeah. Mm-hmm. Non-native commercial fishers. And a lot of them have multiple licenses, not just one fishing license. So they have these huge boats and they're fishing like 2 or 3 licenses on each boat in LFA 34, but yet, they're freaking out over a few natives fishing in there. Oh, those Indians are going to take all the lobster from us, But it's ridiculous if you consider how many traps the non-natives have compared to how many traps the Mi'kmaq people are fishing with. There's far more non-native people out there poaching lobsters than there are actual Mi'kmaq people fishing for lobster.
What does this mean for Mi'kmaq people going forward in terms of exerting their rights?
I think it sets huge precedents because it shows that you cannot charge someone under the Fisheries Act for livelihood fishing because there's nothing within the act. That's what you can't bring judicial notice. That's the big take from this case, is that until there's something within the confines of the Fisheries Act that deals specifically with regulating livelihood fishing, then anything that DFO does is outside the law. So they're infringing people's rights. What they're doing is basically illegal. Mi'kmaq people have a right to a moderate livelihood if you wish to, regulate it, because Marshall 2 says that, the government can regulate our fisheries, but they also said that regulation is limited. It's not a full out regulation, but they have a right to regulate it. However, they had not made any steps to include anything within the Fisheries Act. So it all falls on Parliament. It's been well over 20 years. That is 100% unreasonable. It's negligent on the part of the federal government. And so, therefore, they can't really do anything. And I think that kind of shows it from this case, and it proves that, you can't just go out and arrest Mi'kmaq people for practicing a right unless you have some direction to fall under, some type of law. It's unlawful what they're doing to Mi'kmaq people. And hopefully, maybe the government will act and make these inclusions within the Fisheries Act. And until such time, I'm hoping that the DFO will stop harassing our people.
And are you planning to sue the DFO for the damages that they've done to the clients that you're representing?
100%. We're going to start an action against Department of Fisheries and federal government. They were negligent. They didn't do their due diligence to go out and actually check those traps. They just made this assumption that my clients are doing something wrong based on the fact that they're First Nation. That they're doing criminal behaviors. And so they just acted and made this arrest without even actually doing their job. It would have took them, 30 minutes to jump in a boat, to go out there, pull one of those traps, to actually see that my clients are fishing FSC or not. They didn't. They didn't do that at all, and that's negligent. I'm also going to include racial profiling because, when you selectively choose a person based on, the color of their skin or race, you're racially profiling that person against everybody else and making this assumption that just because they're First Nation, that they're doing something wrong and they're up to no good. They took all those lobsters that they had a right to sell. They took them. The stress, my clients, they have PTSD from this, and that's real. That's real. The depressions that they've been going under, the constantly going back and forth to court. I don't know how many times we attended court prior to actually getting to the trial stage. At least 12, 15 times we attended court, and then that's driving from Sippenagady to Digby. That's a 3-hour drive there and a 3-hour drive back. And then, of course, they had to pay me as a lawyer. So there's the cost of legal fees. Yeah, and then the truck, of course, that they took, the damages to the truck. You can't let a vehicle just sit in some lockup place just sitting there, right? You have to maintain a vehicle. You can't let it sit. So I don't even know if that's a workable vehicle anymore. And then the cost of my client's father having to pay on that vehicle every single month for the last 4 years, even though he couldn't enjoy the truck, couldn't drive the truck.
But do you have any comment on these interim fishing agreements that the federal government is quote-unquote negotiating with these different band councils, which I guess are really a part of the federal government as well? What does this mean in terms of those interim fishing agreements, if anything?
I don't know. My band don't sign them, but I don't understand why they need to sign any kind of interim fishing agreements. We have a right to regulate our own fisheries. All they need to do is create some type of management plan and manage their own fisheries. I don't believe they need to sign anything, but some of these bands that are signing, they're just, the government's offering them money, right? That's what it comes down to. But the only signatures they need from us were on our treaties. Now that Canada has recognized UNDRIP, it provides that recognition that Aboriginal people have a right to govern themselves. We're a sovereign nation. Mi'kmaq people have never given up their sovereignty in any treaty. There were peace and friendship treaties. We never even ceded the land up. So, it just affirms that, we're a sovereign nation and we have to start acting like one. It's just kind of this divide and conquer still with these Indian Act bands and then these Indian Act chiefs that were created by an Indian Act. They forget that we're one nation and that when treaties were signed, there was a nation-to-nation, treaty, and that there was a recognition that the Mi'kmaq people were a nation, and we need to start seeing ourselves as a nation, and stop looking at each other as individual bands, because these bands were created after, like in my community, for instance, after centralization. Mi'kmaq people, prior to that, Mi'kmaq people lived all over the province. And then centralization, majority of them were either pushed to Sibonacity or Ecossassowne. And so we have these bands that are created from Mi'kmaq people from all over. Like in my community, we have people from everywhere. And then even if we go back in our ancestry, for instance, my great-grandfather, Peter Paul, on my grandmother's side, he came from down in LFA 34 area, actually, near Bear River. That's where he originated from. And prior to that, his people lived there for hundreds of years, if not thousands. And I even have relatives from PEI and Ecossassowne, where all of us Mi'kmaq people have either relations here in Shibby or in Ecossassowne. Yeah, there's another story that should be addressed too, is that, see, another big issue, because after Marshall decision came out, everybody was out fishing. And then a lot of times people would get charged. And you're talking, it's like a social issue, so a social problem. And so you have these Mi'kmaq people that have limited education because they're coming from, a history of racism and discrimination within the school system. So a lot of them dropped out of school. And you can't find employment, right? Because of the racism and discrimination again, right? That appears all throughout Nova Scotia. So you have people having a hard time going out, finding work off the reserve. There's limited jobs on the reserve, so there's high unemployment rate. So you have these people that have no money, no source of income, and except for welfare, right? And government's assistance, we call it ration. And so when Marshall came out, everybody was, happy that, okay, well, finally we get to go out and practice our rights and make a little bit of money to live off of. And so a lot of people were out there fishing, and then they're being arrested, like that's still happening today. And so they have no money. They lose everything. All their money that they did have, they invested into like a small boat, or and the boats weren't even that great. Or sometimes I remember fishing on rowboats, or we fished actually off a canoe a few times as well. Whatever can get you on the water, you can go fishing. Even if you just have a couple of traps, you buy used traps. But then DFO comes, they take everything, and so now you're left back on the reserve, no way of generating income. And so when you go to legal aid, you find out legal aid doesn't cover fisheries-related offenses. So you can't get no access to justice at all. So you had a number of individuals, a number of Mi'kmaq fishers that didn't have the money to pay for an actual lawyer. They couldn't get legal aid because legal aid doesn't cover fisheries-related offenses, so they end up self-representing them. And then you have this individual that has limited education. They don't understand the law. They don't understand their rights. And then this Crown, who's educated, comes along and says, oh, well, if you plead guilty to this offense, then we'll reduce the fine to this amount. And then there was a number of Mi'kmaq fishers that end up doing that. And they end up pleading guilty to an offense they should have never been charged with in the first place. And now, after that, once they plead guilty, now they have a guilty plea on a Mi'kmaq person, and they use that as precedence in future arrest. And so it was this ongoing, continuously battle, like where Mi'kmaqs were losing in court because they were pleading guilty, because they had no choice, because they were self-representing. They couldn't have access to justice like everybody else because, again, legal aid does not cover fisheries offenses. So how do you protect those individuals? Like, where's that access to justice that every single Canadian is should be privy to, right? But not these Mi'kmaq fishes. And however, again, like I said earlier, they should have never been charged with these offenses in the first place. And basically, that's what my case kind of proved on Monday, that because there's nothing in the act that can give guidance for DFO, they're being illegally charged and their stuff is being illegally taken from them.
Is there a court ruling or any kind of paperwork that the judge said anything on, or is it just that charges are dropped?
Well, you can get the transcripts. You can contact Digby Court and they'll provide transcripts. He didn't provide a written submission on his, but all he simply said was, he started off court when he first started. He said that he was having issues because the courts couldn't bring any judicial notice, meaning they couldn't bring any evidence in front of the courts, right? Because there's no laws in place regarding livelihood fishing, and then we had a break and he wanted us to think about that. When we came back after about 15 minutes, he told the Crown that the Crown couldn't provide any evidence or prove that FSC is the only fisheries that we're authorized to fish under. None whatsoever. And so he couldn't prove beyond a reasonable doubt that my clients are guilty. And so he dismissed all the charges based on that. But really it was based on the fact that there's nothing within the confines of the Fisheries Act or its regulations that deal specifically with livelihood fishing. There's no laws in place. So if there's no law, then you can't break a law that doesn't exist.